Okay, we're going to be focusing on the judiciary. Again, there are four policy-making institutions in U.S. politics: Congress, President, bureaucracy, and then finally the court system. So that's what we're going to be talking about now. What is the role of the judiciary in U.S. policymaking? As I previously stated, there are four policy-making institutions. So yes, the judiciary is a policy-making institution. There is some political discussion as to whether it should or should not be, but that's largely beyond the scope of the course. In reality, it is, so we're going to treat it as such. The reason why the judiciary is a policy-making institution is because the United States is a common law legal system. A common law legal system has the judiciary interpreting laws passed by a legislative body, but they have to do so in a consistent manner. That is to say, they're going to follow the rule of stare decisis, which means let the decision stand. So what the law meant in the past will serve as a guide for making decisions in the future. Those past decisions create precedents. While this may seem quite natural to many people in the United States and in other English-speaking countries that typically also have a common law legal system, this is not the case all throughout the rest of the world. Many other societies have a code law legal system where courts typically don't make precedent, or precedent has far less value. In a code law legal system, you will find that legislation is far more specific and far more detailed than what it would be in a common law legal system. So, in essence, the job of the judiciary in the United States is to interpret the law, to decide what does it mean, and then to apply the law to a specific set of circumstances or to the specific dispute that is at hand. One of the things the judiciary also does is it determines the facts. In every dispute, there are oftentimes two sets of facts. So it's the job of the judiciary to decide which set of facts warrant acceptance. Which set of facts do you believe? In that regard, we typically see at the trial court level, the jury is the trier of fact. They decide which set of facts are the most believable, and then the judge is oftentimes called the trier of law. That is to say that the judge applies the law to the specific set of circumstances in front of him. It's up to the jury to decide what are the facts. Once those facts are determined, then the judge says, here's what's acceptable. Here's how the law fits. With regard to policy making, there's two different views on the role of the judiciary. There's judicial restraint and judicial activism. Those individuals who believe in judicial restraint believe that the judiciary should be deferential to the elected institutions and not make up policy, as the saying goes, out of whole cloth. By being deferential, they believe this is also perhaps more democratic. So someone who believes in judicial restraint would not believe that it's appropriate for a judge to look into the Constitution and decide that a right is now or could be created or discovered. Much like, probably the best example would be Roe versus Wade. Those individuals who believe in judicial restraint may or may not believe in a woman's right to have an abortion, but they definitely would have a problem with the fact that the court decided that there was this right found implicit in the Ninth Amendment. To contrast with this, you have the individuals who believe in judicial activism. These individuals or these judges believe that it is acceptable for a judge to create policy based upon the needs of the society. So this typically would give a freer hand to the judge and make the judge and the judiciary more of a policymaker on par with the other institutions in the political system. The basic structure of the U.S. judiciary is relatively simple. The court of original jurisdiction for virtually all federal disputes is the district court. If the dispute relates to U.S. law, that is to say laws passed by Congress, the U.S. Constitution, or a treaty, more than likely will start in district court. Disputes that relate to state law will originate in state court. To avoid any type of confusion, all the courts that I'm referring to now are in fact federal courts. Many state courts have names like district court. I'm not referring to them. I'm referring to federal district court. Should an individual not be satisfied with the decision at the district court level, he or she can file an appeal at the Court of Appeals. There are 12 regional courts of appeals. These are called circuit courts of appeals because they handle cases out of a so-called circuit or region. There are 12 of them. The job of the Court of Appeals is to review decisions made at the district court level to determine if the law was correctly applied. I'd like to emphasize that at the Court of Appeals level, it is rare, incredibly rare, that they will overturn a finding of fact. So at the appeals court level, they're not interested in did the jury believe the right side, were the facts correctly determined. What they're concerned about was the law correctly applied. At the top of the federal judiciary, which ironically is now at the bottom of my PowerPoint, is the Supreme Court. The Supreme Court has appellate jurisdiction over virtually every federal dispute. It may or may not have appellate jurisdiction over state disputes. It would only have appellate jurisdiction over state disputes or disputes that originate out of state law if there was a federal issue. As a general rule, when referring to the federal judiciary, all courts, if there is no federal dispute, there is no federal case. Again, as a general rule, when referring to federal courts, if there is no federal dispute, that is to say, a dispute relating to the U.S. Constitution, U.S. law, treaties, or administrative regulations, then there is no federal dispute. There are technical exceptions, but those are beyond the scope of this course. There's another type of court that might be worthy of mentioning, and that is constitutional versus legislative courts. The constitutional courts are the ones that I've just mentioned. These are the ones that draw their authority from Article 3 in the Constitution, the Judiciary article. They aren't necessarily created by the Constitution. Let me say that again. Constitutional courts aren't necessarily created by the Constitution. The Supreme Court's created in the Constitution, but courts of appeals and district courts are in fact created by Congress. Constitutional courts draw their authority from Article 3 of the Constitution. This can be compared with legislative courts, which draw their authority from Congress, not the U.S. Constitution. Examples of legislative courts would be the U.S. Tax Court. Another one would be the U.S. Court of Military Appeals. Because these courts do not draw their authority directly from the U.S. Constitution, their judges don't have a lifetime term. Constitutional court judges do have a lifetime term. Legislative court judges do not have a lifetime term. As a general rule, legislative courts will not overturn acts of Congress, and they hear only specialized types of cases. For example, in tax court, they will only hear tax cases. On the other hand, district court could hear a variety of cases. In fact, district court could hear a tax case, although those are usually assigned to the tax court. There are other courts in the United States, as previously mentioned, state courts, and each state would have its own judicial structure. Many individuals use the term dual court system to refer to the nature of the U.S. judiciary because there's a federal court system that is separate and distinct from state court systems. But this parallel really manifests itself in legislative bodies and in executive bodies.